Welcome, ladies and gentlemen. Thank you for taking the time to join us today for this legal workshop. My name is Orly Alexander, and I will be your MC for today. Before we start, we wish to acknowledge that the land on which we gather we just have someone else joining us. The land on which we gather is Treaty 6 territory, a traditional meeting ground and home for many indigenous peoples, including Cree, Saulteaux, Niitsitapi, which is Blackfoot, Métis, and Nakatu people. We have with us today Anna Kuranicheva, staff lawyer at the Edmonton Community Legal Center. Welcome and thank you for taking the time out of your busy schedules to assist and support our community at this event, especially during these difficult times. We would also like to thank all of you who have come out to participate today and hope that you are able to learn and get support from these sessions. Before our session, I'd like to start with a few virtual housekeeping remarks to explain how we'll proceed. Well, sorry, we have more people joining. That's those. I lost my place. How the event will proceed. We ask that you keep your microphones muted during the presentation to avoid any background noises. Please feel free to ask questions throughout the session if you have one. This session will be recorded and only be used by the Somali Canadian Cultural Society of Edmonton. Therefore, if you do not wish to be recorded, please feel free to leave the session now. In addition, I would like to thank the City of Edmonton and Service Canada for their generous contributions that allowed us to make this event happen today. Just a few words about the organization for those who are not familiar with us. The Somali Canadian Cultural Society of Edmonton has been operating for over 30 years. We provide various programs and services for youth, seniors, women, and families where we strive to develop our community's traditional values and sense of belonging. Among our programs are Iftin graduation, summer camps, including an out-of-city camp called Camp Doso, seniors programs, including a new sewing club for women and seniors to learn how to professionally sew and maybe sell their products in the future. Also, we offer settlement programs where we help the community with their immigration papers and issues. And finally, we offer employment and volunteering opportunities every year for youth. Once again, I would like to express a huge thank you to all of you for attending our session. Now I would like to introduce Anna Kuranicheva, staff lawyer at the Edmonton Community Legal Center. Ms. Kuranicheva has been working at the Edmonton Community Legal Center since 2014. Her focus area is immigration, and she helps also in different areas of law, as well as programs like legal education presentations. Welcome, Ms. Kuranicheva. Sorry, I'm sure I wasn't saying your name right.
That's all right. My first name is much easier, Anna.
Yeah. Okay, well, please proceed whenever you're ready.
Yeah, okay, so I guess we can start. Good afternoon, everybody. So today's presentation will focus on child custody and parenting. As Orly mentioned, my specialty is immigration law, but I also, to a lesser extent, I am involved in family law, in landlord-tenant matters. I know just enough about family law to give you the presentation today, to give you the information about most important parts of this law, how it stands in Alberta. I am inviting you to ask questions throughout this session, and there will be periods for that when I go from topic to topic. So let's say if I talk about the types of custody, then we can, how you can ask questions about custody, yeah, and then I move on to let's say relocation of children from one place to another, so then we can talk about that. So try to relate your question to the topic most recently discussed. I would also like to ask you, if you have questions, try to keep them brief and recognize that we cannot deal with anybody's individual situation or scenario today, like it's a public session, right? So there's no confidentiality provided or can be expected. Whatever your question is, if I can answer it, I will. If not, I will say that, you know, like this is more in depth. I would need to know about your facts more so, or it's quite complex. So please contact our center and make an appointment to speak with a family lawyer. And the contact information for us, for my organization, Edmonton Community Legal Center, is just behind me on the virtual backdrop. So let's proceed. So I have my presentation sort of on my end on the screen, and I'll be moving from slide to slide. Sometimes I may go back to the previous slides, depending on if the question arises that makes sense for us to go and revisit the previous content. Okay. So I will first do a disclaimer, again, emphasizing that I'm providing legal information, so that legal information as in contrast to legal advice, usually means that I will present sort of the lay of the law regarding child custody, parenting, how it stands in Alberta, so that you may have a better understanding of your own situation. But in this session today, I cannot provide you with legal advice. And legal advice is more specific, it's narrower than legal information. So legal advice focuses on, okay, so based on your situation, this is what you should do, this is what you should not do. So that kind of communication cannot happen today, again, because we are limited in time and because it's a public session. But the idea is that, and the expectation, the hope is that the presentation will inform you more about the law, hopefully make you more comfortable with common terms and definitions that are used in family law. And it is also my hope that you will understand the basics of the court process. So having this roadmap and a general picture may prepare you better, may make you more knowledgeable about how to deal with a family lawyer when you actually consult a family lawyer, so that you know what kind of questions to ask, and if they provide answers, you may understand their answers better. What are we going to talk about today? So there are the subjects that are listed on the screen, and the list is pretty long, but the subjects, like I broke them down into easy to understand language, and some of these topics are not going to take as long time at all, but like this list is meant to give you a roadmap so that you know where we start and where we go and where we finish. So specifically, we will finish with community resources, where I'll tell you where to go for the information and what legal service providers you can actually access based on your individual situations with child custody. So the first topic that we will be talking about is child-centered. And this is a very fundamental kind of root concept in family law in Canada, that whatever decisions are made, whatever rights are given to parents, whatever restrictions are imposed on parents, so all of those must happen taking into consideration the child as the center of the attention, the center of the decision making. So with that root concept, child-centered, there are additional key rules that the courts, the judges, the lawyers recognize and remember. So generally in Canada, it is understood and believed that the child should have a relationship with both parents, regardless of how how much conflict, how much falling out, misunderstanding, incompatibility the parents might have. You know, both parents were there to bring the child into this world, and so they both should be ideally contributing to the development and growth and rearing of the child, and the child should have positive relationships and contacts with both parents. And so recognizing that the courts and the judges make decisions giving certain rights or taking away rights from parents and other adults involved in children's lives based on what is in the child's best interest. So that's the main, the crucial, the key question that the judges ask and answer, the lawyers ask and answer when representing their family clients. So now we are going to talk about certain terms. You might have heard these terms kind of thrown around here and there in the community, maybe like through the media. Maybe you already have spoken to a family lawyer about your situation, and you will recognize those. So I will look at them more closely, and hopefully you will have a better and more detailed understanding of what these words actually mean. So the terms in the legal profession, like in family law and other areas of law, often originate from legislation, which is the main law that is passed by the government and where these terms are contained. As far as family law goes, so in Alberta, we have two pieces of legislation. Generally, the main pieces of law in Canada are called acts. And then we have acts, and then we have regulations under the act. So acts are kind of like parents, and regulations are sort of like children to those acts. So in Alberta, we have the Family Law Act that was passed by the government of Alberta, and it only applies in Alberta. And then we have the Divorce Act that was passed by the government of Canada, and so it applies throughout the country. You will see on the screen the differences between these two acts. So those that are not in the overlapping part of the two circles are differences. So Family Law Act applies both to married and unmarried couples, and in Canada it's very common for two adults to start living together and becoming a couple without actually getting married. And so in recognition of that sort of change in the society and the evolving tendency and a growing tendency not to get married, so the government of Alberta eventually passed the law. The Divorce Act is older, and it reflects sort of like a more traditional setup in society where two people would get married and they would start a family, usually after a marriage, and they would usually get married to have the children being raised in a marriage. So that's kind of more traditional and older. The words such as custody, access, divorce, they come from the Divorce Act, and so they are used in proceedings, applications, matters under the Divorce Act. And then such words as contact, guardianship, protection orders, these terms come from the Family Law Act. So whenever lawyers, judges, courts deal with the Family Law Act, so then they use this terminology. So in a way, these terms are, so imagine like these two acts are like some different languages, and so on a different language you use different words that might mean the same thing between two different languages. So with this comparison, for example, guardianship and custody, they are similar. But if you are dealing with the Divorce Act, if you're in a situation where you were married, so then you are mostly talking about custody and using the word custody. On the other hand, if a couple was not married and they are dealing with the Family Law Act, so the language of that legislation applies, and so they're not talking about custody, but they are talking about guardianship. So then we are moving on. So we talked, like I told you, there are two main pieces of legislation: Divorce Act, Family Law Act, and we are going to look at them more closely. Let's first look at the Divorce Act. So as I mentioned before, the word custody is the term that comes from this legislation. And the custody essentially is composed of two big parts. First one is the ability of the parents to make decisions for the child. And then second, the residential arrangement and parenting schedule. So they are kind of like equally at interplay with each other. And if one is removed, so then the custody falls apart. For example, if two parents separated and one parent has the child 10% of the time, and the other has 90% of the time, it does not necessarily mean that the parent with the greatest amount of time with the child has custody, because we go back to these two parts. The ability to make decisions for the life of the child is a vital element of the custody. So it may be, the situation may be that the parent does not spend a lot of time with the child. The child might live with the other parent for the greater part of their time, but both are making decisions, so then both have custody. So then within custody, we have the division between sole and joint custody. So these refer to the part concerned with decision making, not the parenting schedule. So a sole custody, which probably is already easy to figure out, is where just one parent makes decisions for the child, anything concerning the child's life. And then the joint custody is where the two parents share the decision-making responsibility. In Alberta, I should tell you that it is not very common for the parents to be awarded sole custody, because, again, going back to that vital principle that we believe in our society here, that the child should have contact relationships with both parents. So judges, courts really try to facilitate that as much as possible and give both parents a say in how the child is raised and how their lives are built by the parents around them. So with that, there is an expectation for the parents to be able to work together and communicate. Again, I just want to emphasize that joint custody is not about the residential, the division of the locations, and it's not about the residential schedule. So parents wanting custody should have it in mind that it's where the child lives, maybe, but mostly and vitally, it's about making decisions for the child, like where the child goes to school, what kind of treatment, medical care they should be receiving or should not be receiving, what kind of extracurricular activities they are involved in, whether they would be actively brought in the religion of one of the two parents, and at what age they should start being introduced to those religious practices. So things like that. So anything that basically makes up our lives and we would want to impart to our children. So all of that consists of decisions sometimes on a daily basis. And the custody between the two parents would mean that they can participate in making those choices for the children until the children becomes adults. So we have a slide on sole custody. Like I said, most common in Alberta is joint custody, and sole custody is quite rare. Usually with the cases where sole custody is awarded, where there is evidence that the other parent kind of is not around at all. Maybe the parent has not been in contact with the children for a long time. Maybe the parent is ill and unable to make those responsible, mature decisions for the child. Maybe the parent is suffering from substance abuse. So there has to be evidence before the court, before the judge, to conclude that both parents cannot participate in the decision making of the child because just one parent is not capable to make such choices that would be in the best interests of the child. So now we have a chart here that summarizes what I have just said. So sole custody, joint custody, shared custody. So we talked about these three, and I'll just say a few words about split custody, which is like the fourth type of the arrangement, which again, so the parents are participating in the decision making for all the children, but some children may live with one parent, so the family would have more than one child. So again, so the decision making is shared, but where children live, so some children live only with one parent, whether the other child or the other children live with the other parent. So that's what I had about custody. Are there any questions about custody? So sole, joint, shared, or split custody? Okay, so I'm just going, because I can't see you guys on the screen, so I'm just going, so when I say if there are any questions, so I'm just going to wait for a couple of seconds. If I don't see anybody, like if I don't hear anybody, then I'm just assuming that there are no questions, and then I'm just moving on with the presentation.
I do have a question.
Yes, sir.
If my partner has if the child is very small, and my wife, my ex-wife has the custody, and they asked me to pay the child's support about, I mean, the support, and also to pay the daycare, I mean the child care, about $500 for the daycare. And if I'm not allowed to know the daycare, my ex won't let me to know to go and visit the daycare. What rights do I have? Because I don't know whether my child is attending a daycare or they are keeping at home. So how do we get out with this issue?
Well, so was that, so you can always go to the court and apply for an order to establish parenting plan and to have access to the child. So in the situation that you described, is there already a court order?
Well,
do you have a court order, or like is it just like an arrangement, or like have you just dealt with each other, just two of you, without the court?
Well, it is with the court, but the court asked me to pay, you know, the support and the child care, but my ex won't let me know the daycare.
But do you have a provision in the order, or do you have a separate order about parenting that would say that, for example, the child lives with your ex-wife, but you can see the child, for example, you know, for a couple of days every week or on the weekend? Is there anything like that that you have in writing from the court?
No, I don't have in writing, but the conversation with the mother of the child, she's supposed to bring the child in a place like the public place, because the child is too small, and then she will come and pick it up. Sometimes she's late, so and I don't want to create a problem. So,
Well, yeah, so then let's say, like ideal, and I'll talk, like I have a separate slide on that, like ideally try to reason, work it out with the other parent, that you should be given some time with the child, and it doesn't have to be in a public setting only. If the other parent digs in their heels, if they are not cooperative, then you will have to go to the court, and you can ask for a parenting order. So then the parenting order would be separate from child support, and then you can present evidence. So it could be done in writing, or depending on which court you go to, you can present your evidence by talking to the judge. And again, the judges have to decide. Judges always have to have the question in front of them: what is in the best interest of the child? Recognizing that the children generally should have relationship with both parents. So in your case, the judge could decide that, well, there are no reasons that you cannot see your child. There's no reason that you should not be spending time with the child, somewhere like in your house, for example, not a public place, because there's no evidence that you are violent, that you have substance abuse, that you have questionable people in your residence, that your residence is not safe. So like if those dangers are not there, part of the picture, so the court may well issue an order to say that you should have access to your child, and that you could request the court to make it more specific, so that it says, every weekend evening, or every other day, you could come and visit your child, so that the child can spend time in your residence. So that's how you would deal with that, to have access to your child if the other parent with whom the child lives is not cooperative.
yeah, but I afraid if in case I bring my wife into my house and my ex accuses me, or the child has the bruises here, the scratch. So I worry if the ex is not collaborating, and she is not a nice person. So I worry for being accused for something that I didn't do.
Well, if it is in the court, if it comes to the court, right? If it comes to the judge to make an order about how and where the child should spend their time, the judges don't take accusations lightly. They make decisions based on evidence, based on facts, what actually has happened, and what is happening. So, for example, if your ex-wife is saying, well, I don't want the child to be with my ex-husband, because he has parties every day. Well, then, like, what is the evidence of that? Has she seen those parties? Does she have any witnesses of those parties? There's nothing like that. If it is just her words, and if you say no, that is not true, and let's say you have roommates, or you have somebody else living in your house who can also provide their statement to say that like it's quiet, that you're a responsible person, your house is clean, you can provide pictures of what your house looks like. So then the judge would look at what you say, what the other party says, and they will decide whom they are going to believe. But generally, for any accusations, for any claims, there has to be evidence. If there's no evidence, that quite likely those especially accusations, kind of like negative statements about somebody, so those would not be believed. Okay, so sorry, actually, so
Thank you.
in the interest of time, you do have to move on, but the question was basically became a bridge, like a nice bridge to my next topic, which is access. So legal term access. Again, remember, we are sort of in the territory of the Divorce Act. So and so the Divorce Act operates in terms of custody and access. So it is quite possible that that the custody is given to one parent, but the other parent without custody still has access. So remember, custody is by and large about decision making, but recognizing that The child should have a relationship with both parents. So maybe one parent is much better equipped and positioned in life to be making important decisions about the child, but the child should still know the other parent. So that other parent is given access. And access includes the right to ask questions and to receive information about how the child is doing in school, with their health care, with their extracurricular activities, with any, let's say, sort of, religious activities that the residential, the custody parent would want them to participate in. So if there is a court order, if there is about a parenting plan saying that, parent Y has custody and parent A has custody, but parent B has access, so that parent B, could ask and expect to receive answers about the child. The terms of the access could also, in the order, could also include details which I gave when discussing that gentleman's particular situation. So, like times of the week, times of the year, times of the day, like public place, so the parent's residence, or like a neutral ground, like a mall or like a playground, so things like that. So where the child could spend time with the child, so that would be encompassed by access. So now let's talk about the Family Law Act. So remember, so the custody and access, those are the terms under the Divorce Act used only for married couples. Now, Family Law Act, that's the provincial legislation, and so this will be the act which could be used by married couples, but also unmarried couples who at some point decided to have a relationship, live together, have children, but they never officially got married. So under the Family Law Act, there's no such a term custody. So custody is kind of the language of the Divorce Act. In the Family Law Act, the term is guardianship. And they are similar between themselves. So guardian is somebody who is responsible for the care, upkeep, well-being of the child. In Alberta, it is so that how the law functions is that each parent generally is presumed to be a guardian unless something happens, like evidence comes to light that one of the parents cannot be a guardian of the child. But generally, sort of so far with our whatever we know happening and whatever happens with reproductive activity of humans, so there are two individuals are necessary to conceive a child and bring a child to life. So there are two. So they are presumed to be guardians, biological parents especially. With adoptive parents, it becomes sort of more complicated because adoptive parents have to go through a legal process first to become adoptive parents, but biological parents, so like once there's no question that somebody is the biological father, biological mother, so they both have guardianship. And then the guardianship could be taken away if there's something about that one parent that makes them unsuitable to care for the child and to ensure that the child lives in a sort of in a healthy and positive environment. So parents who are guardians, again, because the guardians and custody are similar terms, so they have joint decision-making authority. Again, important decisions about the child's life, education, healthcare, religion, extracurricular activities, things like that. But then the court might intervene and or the parents themselves might decide that, let's say, one parent with whom the child lives, they would be making decisions about extracurricular activities and school, and the other parent who does not see the child so often, the child, that other parent might decide that, okay, I don't need to decide on all those things because I trust you. The child lives with you, but I want to be involved in healthcare decisions because health is very important for anybody's life, and my child is important to me. So even though I am not there for the child every day, I want to know what kind of treatment they receive, you know, what kind of choices there are for treatment. And so then, yeah, I want to have a say in that for the well-being of our child. Something about guardians that is quite distinct is that the guardians do not have to be biological parents. So remember how I said with the previous slide that both parents are presumed to be guardians? That's true, but then somebody else can also become a guardian, like a grandparent or an aunt, or even somebody like from outside of the biological and sort of blood connections within the family. So that would have to happen through the court. Like the parents, they don't have to go to the court to establish that guardianship, but anybody who is not a biological or adoptive parent would have to apply to the court for a guardianship order. And it could well be that one child could have, you know, 3, 4, 5 guardians, depending on the situation. If the situation is such that, you know, maybe like one biological parent is completely out of the picture and the other parent has limited ability to be making all the decisions, maybe because of their mental health, maybe because the parent is not very mature in life. If it is like a very young parent that they just don't have that much life experience to consider everything for their child. So then, you know, let's say that the parents of the parent could become guardians. So then there is a biological parent and 2 guardians in the picture. So now I have a long list, which kind of might look scary, that it's just like too much text and too much sort of information to absorb. But these are the dimensions of being a guardian. And so lawyers and family law judges look at this list to figure out what kind of arrangement, especially if guardianship is shared, what kind of arrangement is going to be the best for this particular child. So they would assess the family circumstances, what's happening in one parent's life and the other parent's life, and so like what is the child, like how old is the child, like what is the child, what is their health, religious background. So kind of they take all of that into consideration and then look at this list and decide that, for example, okay, so making daily decisions about the child, you know, in this case makes sense for parent A because the child is with them most of the time. But deciding the children's religious upbringing really should be divided between the 2, because the other parent B, is also involved in the child's life, and let's say they share the same religious background, parent A and parent B. So there's no reason to exclude parent B from the child's religious upbringing. And then generally, when it comes to making such decisions about who gets custody, who gets guardianship, who gets access, there are lists of factors of different dimensions that lawyers and judges go through to make it very specific how, you know, the child's life is going to be sort of allocated between the 2 in these different areas of life. So then we are moving on. So now contact order. So you so this is a pronouncement by the court. So whenever we say there is an order, that usually means a court order. So this is a permission given to somebody who is not a guardian to spend the time with the child. So this is similar to saying access to the child under the Divorce Act, but remember, so now this is the Family Law Act. So here we are dealing with the different terminology. So contact order comes into play. There's a bit of a complex procedure to get a contact order. First, the parent who wants contact, or anybody who is not a guardian, but they believe that they should have contact with the child, so they have to go to the court, and they can't make an application first. They must first ask for a permission to make the application, and in legal terms it means that they have to ask for a leave to make an application, which kind of just creates like a separate step for this non-guardian person to convince the court that they are, like, their presence in the child's life is important, that it is in the child's best interest to have contact with this person. So basically there's a bit of like, there's more sort of convincing that this person needs to make for the court. That's why they need first to ask for a permission to make an application, and then they actually make the application and present evidence about, like, you know, why they're so well suitable to also have contact with the child. There's one exception for grandparents where parents are separated or one parent is dead. So in that instance, so the grandparents, once they can prove that they're grandparents and there is proof that the one parent is dead, then they basically just make the application without that intervening step for permission to ask for an application. So which court should you use? So we have two levels of court in Alberta: Court of Queen's Bench and Provincial Court. And so they, like, the way how they divide their operation in family law matters is related to the division between Divorce Act and Family Law Act. So Divorce Act, so for married people only, so dealing with custody and access, they can only go to Court of Queen's Bench. With the Provincial Court, dealing with only family law matters, Family Law Act matters. So this only can be dealt with at the Provincial Court. So you see that it's tied to which piece of legislation is going to be used, and usually it's the family lawyer who looks at your case very closely, specifically, and attentively. They will tell you which act you should be dealing with, whether it's more about custody and access or guardianship. So then Family Law Act, the Divorce Act, and then depending on which act, so then you know which court you should go to. I have a chart here briefly comparing the differences between the two levels of the court. So let's say if you're in a situation where you could either go to the Provincial Court or Court of Queen's Bench, so if you have that luxury of choice, you can consider like which one is better for my situation. Generally, Provincial Court is less formal. Your judges are sort of, more patient with self-represented people, because people who are self-represented, there are more of them at the Provincial Court. The procedure is slightly less complicated. The fees, the costs tend to be lower. The judge has the ability to soften the rules, to allow for late filing, to allow to reschedule something on a very short notice, to allow you to speak right there at the hearing at the court. They can, go through the matter, go through the documents. If they have questions, they just ask the questions right on the spot. With Court of Queen's Bench, it's more rigid. there are more rules, the procedure is more complex, it's more expensive. Generally, it does make sense to hire a lawyer, even like for a limited amount of service, to deal at the Court of Queen's Bench, because it can become more overwhelming, and judges are much less amenable, and they're much less willing to kind of bend the rules and allow for exemptions. So for example, with the Court of Queen's Bench, if you make an application, so you have to provide evidence, right? Remember, so whenever you say what you are doing, what the other parent is doing, to prove that, you have to provide evidence. In the Court of Queen's Bench, usually this evidence has to be in writing. So, and this is usually where a lawyer's help is needed, to sit down with you and write paragraph after paragraph, you know, what happened, what you are doing, what the other parent is doing, what the other parent is not doing. So that has to be in writing. It has to be sworn by you as the statement is correct. If you want to refer to any documents, they have to be attached. They have to be filed with the court a certain amount of days in advance. And let's say when you're actually in the court making your application, if something else comes up, or if you realize that you forgot to add something into your writing, it's very difficult to make it part of your evidence, because again, you know, there is a rule, there is a procedure, evidence must be in writing. The Court of Queen's Bench is much less flexible to make those concessions and still allow for for a correction or something to be added quickly. So we are moving on now, and we are going to talk a little bit about best interest of the child. So as I told you before in the introduction, this is a fundamental kind of principle on which the family law in Alberta and in Canada rests. So the judge is always supposed to think about what is in the child's best interest. When one parent wants A, the other parent wants B, maybe there is somebody else applying to become a guardian. Different circumstances come into play, like changing residences, relocation, knowing about the child, not knowing, meeting in a public place, private place, demanding that the other parent pay more money for the child support, for special expenses, preventing the child from being with the other parent, or preventing the parent taking the child to, let's say, you know, like a religious event or like a trip somewhere. So all those things, whatever decisions are made in the court, like fundamentally, like this question should always be hanging sort of in front of the judge's eyes. So what is, you know, if one parent wants A, the other parent wants B, which of them is in the child's best interest? Now, this is, of course, like a very kind of general, wishy-washy, even if you wish, term, like best interest. What does it mean? You know, we know the word interest. We know that, you know, best interest means something good happening in a person's life. So in our law, we have like a pretty exhaustive and thorough list of different elements that basically are included into this definition. So you can see, again, the list is kind of, you know, long, maybe a bit scary and boring to look at, but this is what the judge would go through when they would make a decision on whatever aspect of the child's life. So they would have to consider all these dimensions. So, you know, like emotional connection between the child and the parents, the stability of the home, the history so far, look at the child, the cultural, religious background, what if the child is mature enough already, what does the child want themselves? So they should be given their voice at a certain point in their life. Yeah, so all of this, so like judges would treat it like as a checklist or as like as a toolbox. Yeah, so, you know, picking out sort of one tool, looking at it and sort of, you know, adding this into the decision about whatever course of action. So then we are moving on to the next, moving on to the next slide. And this is basically a continuation of the children's best interest. So this is like a second list of factors, which again, so the judges would use like a toolbox to pick out and apply to a decision to make, like from custody to who has access to how the custody is divided. So like ideally the court would look at all of these and kind of answer these questions for themselves, and then come to a conclusion that this parent should have custody, the sole custody, which would be a rare case, or the child should live with the parents 50-50, or the other parent should not be allowed to do certain things, although they can make some decisions. So again, so that would be the ultimate conclusion. But to come to that conclusion, the court, the judges have to go through this exercise and apply all of these questions, answer them, and relate them to the final outcome that they want to arrive at. So let's look at a couple of scenarios so that you can see how the best interest test is operating in practice. So we have a couple, Jane and Joe, getting a divorce. They have 2 children who are 8 and 10. Joe has worked out of town for most of the children's lives on a rotating schedule, 10 days away, 4 days home. Now, Joe has taken the kids to sports activities when he's at home, but it was Jane who was in charge of the household for the most part. They've lived in Mandair, which is a small town not too far from Edmonton. And Joe has rented a place in the same town just down the street from Jane. So let's say the judge has this scenario. They received the evidence about these arrangements from both parents. So what custody arrangement would work for this family? So the judge would again have to remember that the children's interests are the primary question to answer, and they would also need to remember that the children should have a relationship with both parents. So let's see, would a sole custody arrangement be in the best interest of the child, of these children? Probably not, because even though Joe has been out of town for, let's say, 4 days today, so he's not around as much as Jane. He does take the children to the activities when he is at home for those 4 days. He is going to live very close to the children. So I guess we don't know enough to be concerned that he should not, he should have limited access to the children. If there are no reasons to prevent the children from living with Joe, so the judge might well decide that, okay, well, they're living close to each other, so then it should be fairly easy to coordinate pickups, drop-offs, the delivery of the children to the school, and the children are not going to spend too much time commuting and kind of getting shuffled from one location remotely to another. So it might well be in the interest of the children to have a shared residence between the 2 parents. Now let's look at a different scenario. We have Jill and Peter. So they are getting a divorce. They have 4 children who range in the age from 4 to 13. So Peter has worked out of town for most of the children's lives on a rotating schedule. And he does not only that, but he doesn't spend much time with the kids when he's at home. So that's unlike Joe in the previous scenario. And so far, Jill has made all of the decisions for the kids so far. So they have always lived in Edmonton, and they plan to continue living in Edmonton. So in this situation, let's say if the question was, where should the children live? So they're quite like a diverse range of age there. Yeah, there are 4 of them. So based on what we know about this family, is it likely that the judge would say, okay, maybe half of the time the kids would be with Jill and half of the time the kids would be with Peter. It's in their best interest. What we know about this family, probably that's not going to happen, because we have the evidence that the father does not spend, like, first of all, the father is away for quite some time, just like in the previous scenario, but unlike the previous scenario, he doesn't have really spent much time with kids when he's at home. So it's not likely that it's in the best interest of these 4 kids to spend half of the time with a parent, you know, who has not been so involved with their lives. Let's say if Peter says that I want to be involved in all decisions about our kids' lives, I want us to have shared custody, and it really has to be, we both have to be involved in all of the decisions. And Jill might not agree with this, because maybe, let's say, they are in a serious conflict with each other, so it's difficult for them to even communicate with each other, with these 2 parents. And now Peter wants to be involved with everything, so that means that Jill would need to tell him, to ask him for his opinions, things like that. So Jill might disagree that he should have custody and the decision-making power. So if it were to come in front of a judge, Jill would show the evidence that, you know, so far she has been involved, she has been making all the decisions. Peter did not really ever care much, you know, he did not do research, he did not really contribute to considering A, B, C, things like that. So now that he wants the custody, but is it really going to work for the children? So Peter's application for joint custody probably is going to be denied, because again, it's not in the interest of these children to have, you know, Peter entrusted with important aspects of their life. Now, let's say if Peter wanted to just have access to the children, and, you know, he doesn't care about the decisions in their lives, but and he doesn't spend very much time outside of work, but he wants to know what's going on with children. He wants periodically to spend time with them. So would he be allowed that? Probably yes. Again, we have like no information here that, you know, the Peter is dangerous and suitable in any way. So in the best, generally children should have contact with both parents. So far, children have mostly lived under the care of the mother. So that's not going to change if Peter periodically is going to spend time with them. So there's going to be no disruption, no trauma for the children. If they spend time with their father, they are both living in the same city, so not much time and cost is going to be involved in getting children from one parent to another. On occasions when the father wants to be with the children. So yeah, so from this scenario, quite likely that Peter would get access to the children, but not shared residence and not custody. Now let's take a look at another scenario which sort of presents like more like serious, more negative circumstances. So we have Betty and Tim getting a divorce. They have 2 children, 7 and 11. They raise the kids together. But recently, Tim thinks that Betty has been drinking a lot. They separated. Tim is concerned for the children when they are with Betty, if she's been drinking. So from this scenario, we can guess that the time that children spend is divided between the two parents. But now in one household, there's drinking going on. So let's say if Tim wanted to have children with him, to live with him as their primary residence all of the time, so with the evidence of drinking, he might well get the residence, the primary residence for the children with him, because with the evidence of drinking, the court would think, the judge would have to think, so again, best interest of these children, clearly not to have the parent, let's say, intoxicated. The children are 7 and 11, so they're quite young. They need supervision. They need to be watched, and they need to. So there has to be an adult keeping an eye of them. And if one parent is drinking, even at home, it could be just plainly not safe for these young children to be left to their own devices while the other parent is incapacitated to an extent. So shared residence for the children is going to be out of the picture. In terms of custody, would Betty have custody together with Tim? So custody again is joint decision making. That would depend on, I guess, the extent of the problem with drinking for Betty. If it is maybe just like once in a blue moon, maybe once in a couple of months, or if it happens every weekend, or if it happens every other day, and then let's say other parts of Betty's life are suffering, like maybe she's lost her job, she was evicted, forced to move to a different place because of the drinking problem. Maybe the house is now in disarray and not in a good condition because her alcoholism kind of makes it difficult for her to kind of pay attention to those other parts of her life. So if we have evidence of that, so then making decisions about where the children should live would not be left to Betty. If the alcoholism becomes a really serious problem, let's say that she's sort of not in a good presence of mind most of the time, then probably she would not have any decision-making power given to her at all, because to make a serious decision about a child, kind of, you need to be certainly with clear focus, like a clear sort of, vision of, if we do this, what's going to mean for the children, like in a short term, long term. So if her mind, if her cognitive operation is impacted by the alcohol so much, then probably she's not going to get the custody. Would she get access and sort of contact with children? Again, it would depend on her problem with substance abuse, and so more facts would be needed. So the judge would look at those facts, and again, keep in mind that ideally children should have access and contact to both parents, but here we have one parent that is much better suited and the other parent not so much. So maybe the contact with the second parent, while still important for the children, is going to be minimized for the children's best interests. Okay, so I finished with best interests. So maybe we'll take a moment or like a break in terms of answering questions before I move on to the next topic. So are there any questions about these decisions for the child's best interests? If you have questions about which court to go to, yeah, so basically this is what we have talked about so far. So again, I'm just going to wait for a few moments and then if not, move on. Okay, so there was a silence, and I take this silence as a sign of no questions, and I appreciate that some may have technological difficulties to unmute themselves to maybe get their question heard, but in the interest of time, we just can't be waiting for a long time, and because I don't see you, right? I don't see that anybody would like make a visual cue with a question. So so this is just we are just limited technologically in this way. Let's talk about parenting plans. So parenting plans should be put in place whenever the parents separate and whenever both parents want to be involved in the life of the child in whatever extent. Either they share custody, they share the residence of the child, they share access to the child and contact. Maybe there are other people involved in the child's life. So it has to be kind of worked out in terms of details, the schedule, conditions, maybe certain restrictions, what should not happen. And so all of those details need to be put together in a plan. The parenting plan may sound very official and formal, but it does not have to be, like, it doesn't have to be necessarily a court order, and you don't have to have like a lawyer involved, like through all the steps of the process. But at the very least, it should be in writing. It could be, like very plain language, but it should be in writing and signed by both parents, so that everybody, well, both parents understand like what is going to happen in the child's life in whatever dimension. These parenting plans are not set in stone. They might change, and they should change, because of course children grow and their needs their needs change, and then their preferences and views might be changing too as they are maturing, and then they would deserve a voice too, to be heard, for these decisions to be made for them in terms of like where they live and how much they live with parent A or parent B. With parenting plan, so there is so remember, so I told you that both parents are presumed to be, both biological parents are presumed to be guardians of the child, unless there is a reason to take away that guardianship from one parent. So that's kind of set in stone, that presumed, but there's no presumption of 50-50. So again, it would depend on the circumstances, the condition of the family, of the two parents. So now the two parents have their own separate lives. So the division could be, 30-70, 90-10, depending again, like what's happening there. And again, courts and judges would have to really consider every angle, every aspect, every possible configuration from the point of view, what is in the best interest of the child. So we talked about how they consider all the circumstances. They have to be practical and consider what will work from a realistic point of view. For example, if one parent works out of town for a long, like very often, and they go away for long periods of time, so parenting plan discuss the parenting plan should not establish the shared residence between the two parents 50-50, because it just doesn't make sense. It's not practical. Even if the parent says, well, whenever I go away, I can take the child with me. It will be fun for them to travel and see all these places. But the child needs stability in their life. When they're school, they should not be disrupted, taken away from the school. So even something that the parents can agree that could work between them, like they could agree between themselves, and they just want the court to kind of look at their proposed plan. If the judge says, well, that's not practical, that's not really realistic, then certain provisions could not be put in place. Remember how we talked about different factors and sort of aspects to take into the consideration to determine the best interests of the child, to questions to ask in terms of who should have custody and what decisions. So there's a similar list of considerations and factors that would come into play devising parenting plan. And this could be, again, used as a tool to sort of ask the question, answer the question, and answer to the question would help parents facilitate the details of their specific arrangement given their circumstances. These are the main sort of examples of life where the parents should consider that they should put their minds to when they figure out, okay, how we are going to divide ourselves in the life of our child. So the questions range from making decisions, like usually serious decisions are school, like education and healthcare, then residents, who they live with, how much time they spend, how much time would be spent with other people. So some of these questions be more important or less important depending on the circumstance, but like ideally the parents by themselves or through their lawyers should kind of sit down and go through each question and figure out, okay, if this question is important for our lives, how we are going to answer it. And the answer should be in our parenting plan. Are there any questions about the parenting plans? All right, so I kind of held a deep breath and I counted to 5 or 7, so there were no questions. We are moving on. Problem resolution. So, the topic of our presentation by itself suggests that there is a problem in the first place, right? So the family, the relationship is deteriorating, marriage has fallen apart, the family is no longer one unit as a family. So that's a problem already. And of course, we always want to have solutions to our problems in life. So with the deterioration of the relationship, the falling out, the end of the family, that's a legal problem. So let's look at what kind of legal solutions there could be. So there are, this is a very handy chart. Well, I think it's handy. So it's presented like as a spectrum from one end to the other end. So on the left-hand side, we have sort of the part where you as the parent have more control over decisions concerning you and the child. And then on the other side of the spectrum of the line, on the right-hand side, less control. So of course, you want to have more control about about the decisions that impact us and our children. But generally, we are independent beings, and we, by and large, don't like to be told what to do, and we have our interests and needs and wishes, and we want to have them happen for ourselves. But that's not always possible in family law, with family law problems, because it's you and then the other parent, and so they may have their own needs and wishes, and they equally don't like to be told what to do, and they want to have sort of their word, their say. And so sometimes we can figure it out on our own, or we can't if there is a serious conflict, when we just can't reason with each other, and we need the intervention of people, other people, and systems such as lawyers and courts. So let's take a look at these 4 different ways that give us control or take away control to find legal solutions. So first of all, we have a DIY, which means do it yourself. So parents can make their own parenting plan. They can sit together, discuss the matter. They can sort of, go back and forth through text messages or through email. That's the ideal situation where 2 parents can actually talk to each other, and they can talk to each other constructively without accusing each other, without remembering all the bad things that one person had done to the other, but they accept the reality that they cannot be together anymore, but the children should have access to both parents. Is good for their lives, for their development. So how can they make it work? There are different resources that can help parents to do it on their own and put together a parenting plan. So there's a parenting after separation guide that has been developed by the government of Alberta. So together with this guide, there is a course that used to be offered in person, but now because of COVID, so much has been moved into the online reality, and so this course now is available as an e-course. So these resources would help to give food for thought, to give tools to parents who might be on good terms with each other, but they're afraid that they might not consider all the details and all the sort of nuances and complexities of putting together a plan. So they need external help, maybe more detailed information. And this is where these resources would come into play. Ideally, each parent should get their own legal advice, consult a lawyer. So even if just a couple of consultations or one consultation where the lawyers, the family, especially the family lawyers, they are trained to always keep in mind the best interest of the children and factors, and guardianship versus custody, and different factors. They know which court would work the best if they needed to go to the court. They know the procedure. They can address sort of realistic outcomes of scenarios, like what if this happens, what if that happens. So that all of that might impact on what the parents agree on together. And so then, ideally a lawyer should be involved, not the same lawyer for both parents, but each parent should consult their own lawyer if it is just like a one-time session to get that competent guidance. So then let's take a look at mediation. So mediation is the kind of least intrusive when the two parents cannot sort of see eye to eye just themselves, and whose interaction with each other is not very constructive and does not result in positive results. Sometimes mediation cannot be appropriate if there's a high conflict situation and the parents really, so to speak, hate each other's guts, or if one parent is violent, abusive, controlling, and the other parent feels very vulnerable, kind of being controlled, dominated. So then just involving a mediator cannot help because of that imbalance, because of that already very unhealthy dynamic between the parties. But if those negative circumstances are absent, then mediation could be a way to go. There are mediators, like they're private mediators. These are usually lawyers who are trained in mediation, so that can be accessed and purchased as a service. So a mediator could help to figure out a parenting plan. For some families, for some circumstances, mediation could be offered at no cost. So this service is provided by the government of Alberta. I have the link here on the slide. If you cannot easily copy the link right now, you can also just do a Google search, Alberta mediation family law. This link should come up because this is how I tried it with these keywords. It worked. So this link will take you to the website of a legal resolution service, and where they describe their mediation program and resources available for mediation. So you could check it out. Now, because of COVID, procedures, availability of programs and services might be different, and it might fluctuate from time to time. So that's why I cannot give you a lot of information about their mediation services right now, because just our situation is very fluid with the public health restrictions, closures, and the state of the pandemic. So then for mediation, we go to collaborative family law. So this is more intrusive now. So this is where two parents each get their lawyer, and the lawyer is not just there for a consultation or for one instance of advice, but they are involved along the way. And so the lawyers talk to each other, representing their respective parents as clients. A contract is signed that the parties, the parents, are not going to go to the court, but they will work together with the other parent. So the overarching idea is to avoid the expense, sort of the uncertainty, all the negative emotions and experiences associated with having to go with the court. But so the parents might or might not be in a good relationship with each other. You know, they might resent each other. There could be sort of a lot of bad blood, so to speak, but they still agree to work together with the other parent for the sake of their children. And they involve their lawyers in this sort of, you know, joint communication, in the joint venture. So the parents don't talk to each other, but they talk through the lawyers, and because it's called collaborative. So most decisions are deliberated, discussed in like with 4 people present, so 2 parents, 2 lawyers, and information is openly shared. It doesn't mean that one parent cannot say anything in confidence to their lawyer, but so there's always that once you hire a lawyer, the lawyer has to keep your information your lawyer cannot release the information without your consent to anybody, like generally. But if with the collaborative approach, you would have to agree to give consent to disclose the information about certain circumstances involving you and your child, to be communicated to the lawyer of the other parent, so that the decisions are made kind of, you know, jointly with this sort of, you know, positive brainstorming. So collaboration happens by lawyers. Like I told you before, that mediators are not necessarily lawyers, but collaborative family law, so they have to be lawyers, and so they have to go through a specialized training to become collaborating facilitators. And so then the most intrusive way to decide on custody and child and family law matters is to kind of, you know, the old-fashioned way, maybe the way that is known most commonly, is to just have the courts decide on what's going to happen and how the life of your child is going to be divided between the 2 parents, and which parent can do what. So this happens often when 2 parents cannot decide for themselves, when they don't want to cooperate with each other, when even understanding that, you know, the children are hurting from the conflict, they are just not capable of, you know, sitting together and figuring out an arrangement that is going to be healthy and positive for the child. Or when one parent wants to do that and the other parent does not want to do it, so then the court's intervention can be necessary. Like in that example that we had from the gentleman who asked the question in the first part of the presentation, where he was expected to pay the child support, so he may have wanted to be involved in the life of the child meaningfully, but the other side, while taking the money, the other side was preventing the parent from seeing the child, and maybe spreading lies and allegations about the other parent that were hurting the parent, maybe that were hurting the relationship between the parent and the child. So then in that kind of situation, if the gentleman wanted to have good, positive contact with the child, probably he could not reason with the ex-spouse just between 2 of them. Maybe mediator would not be successful. Maybe collaboration process would not be successful. So then he would have to go to the court and basically force the court to give him access to the child on certain terms and conditions. He would have to show to the court that whatever the spouse is saying is not true about him. So yeah, there has to be that strong kind of external like hand of the court to make those decisions, because just too much has been broken between the parents, and so reparation without the court is not possible. We know that lawyers are expensive. Full representation is particularly very expensive, but now there is such a service, limited scope retainer. So this is where a lawyer does not become sort of your lawyer for your, for many years to come, or for like your whole matter figuring out like a particular problem. But the lawyer gives you help, provides you service for a certain part of the legal problem, but not all of the services. So for example, you can figure out a parenting plan with most of the aspects of the child's life and your involvement in it, but let's say you disagree on whether or not the child should be taken for summer holidays to a different country so that they can spend time with the family of that other parent. So you don't want that, and so then you can't agree on that, and you would want the court to decide. You kind of, you were okay to put together the parenting plan, but you can't figure out the process how to bring this application to the court about where the child would spend their summers. So in that instance, just for that particular part of your parenting arrangement, you want the lawyer to help you. And so then, because the lawyer is not taking on the full case, the full matter for a long period of time, they would not be charging you as much money or on a continuous basis. They normally, with limited scope retainer, the lawyer would tell you, okay, I can do ABC for you, and this is going to cost this much money. And so then upfront, and so you make your payment and you receive this particular service. Then you don't pay more after that, but at the same time, you can't expect the lawyer is going to just continue doing things for you indefinitely. So still on the subject of the court, on these slides, parents can hire a lawyer or self-represent, and I should say that it's not a requirement that you have a lawyer, but if it does come to the court, then even for a limited scope retainer, even to help you understand the procedure, the process, which court to go to, which forums to use, how to present your evidence, how to collect, like what kind of evidence even together that you are a parent who is well suitable for the child to spend half of the time with. So a lawyer can guide you on that on a consultational limited scope basis. But again, it's not a requirement. So, anybody can file an application, and anybody can represent themselves in the court. So the result of court hearings is usually an order. It could be a final order or an interim order. Interim means like a temporary order, recognizing that there's a certain circumstance and it might change in a couple of weeks, in a couple of months. So then it cannot be final. So now going to court. So as I said before, it is quite expensive, kind of nerve-wracking, time-consuming. You can never be assured of the result. So it's best to avoid going to the court. But there are all kinds of situations in life where just sitting down and talking, trying to figure out a solution simply is not realistic, not possible. So there are certain reasons when the court's intervention is necessary. And these are there are 5 situations that are listed on the slide where even if you think that, well, court is expensive, it's, too much time, I'll have to spend, I'll have to miss work. But these are the situations where court's intervention is a good idea, because just between 2 of you, you will not work it out well for the safety, for the well-being, for the best interest of the child. So situations such as safety now of the child is a concern when they are with the other guardian, and the guardian and the other guardian, the other custodian parent just maybe denies that there's any problem with the safety. So then, so as much as they would want you to believe that no, like everything is okay and nothing to worry about, you know, if you have your reasons to believe it's not, then probably the court should get involved to have that little extra level of oversight and ordering and power in terms of if the child can spend any time with that guardian or not. If you personally feel unsafe or intimidated, mistreated by the other parent, so then because of that negative dynamic in the relationship, even if you were kind of getting together to work things out, to discuss it, if you already feel that the other side is not treating you respectfully or fairly, or if the other side is doing something to minimize your presence in the life of the child, so then even if you are, you know, technically still talking to each other, the communication is unhealthy, it's toxic, so then the court application makes sense. So I talked already about the reasons to avoid going to the court. So like they are listed here, and like I'll just summarize them for you again quickly. Like it's kind of like common sense, but they're handily presented for you like in one place on the slide. So maybe it will become a motivator and a reminder for the situations when the conflict arises. That maybe, you know, you could try to make things work just between the two parties, because otherwise you have to go through the court process, and there are these reasons why it would be like it would not be beneficial for your lives and for the child too. So it is expensive. Even if you qualify for legal aid, you should all know that legal aid is not free. So the lawyer would be given, but there is a bill attached to the lawyer's service, and at some, like, you will have to repay it, and legal aid would put you on a repayment schedule depending on your financial capacity, whatever circumstances in your life. So it could be, you know, a certain amount of money every month, or maybe like the first year not paying anything and then starting to pay the next year. So like even with legal aid, yeah, there's not such a thing as just like a free service for the court representation. Court proceedings are usually very lengthy, and now there are delays accumulating and happening because of the serious closures during COVID between March and June, more or less, where so many matters were on hold and courts are now facing backlogs. Then again, the matter is out of your control once you present sort of your life circumstances and evidence before the judge. So the judge would be deciding about your life and about your children. So, you know, even though that decision would have power, but it does not come from you, and it might be sometimes unnerving, stressful, and unpleasant to know that there is this stranger making a decision about how your child spends their time and with what parent. Something that I also will point out to you, that there is never a guarantee of a certain outcome with the court. And, you know, as lawyers, usually, well, as like we all as lawyers, as law students, we are always trained to tell our clients that, you know, they have a strong case or a weak case, they are likely to be successful, not likely for, you know, A, B, C, D reasons, but the success can never be guaranteed. So, you know, even if you ask the lawyer that, you know, like, will I win this case? So you should not expect like the answer, oh, definitely yes, it's just going to be a piece of cake, because there's always a possibility that, you know, like new evidence might come to light, or, you know, the judges do have discretion in terms of how they apply the law. You know, like even the concept itself, best interest of the children, as I said before, it involves many questions, many factors, and so no, you know, if you put two judges together, so they would not answer these questions identically. So even if a lawyer thinks it's a strong case, the judge might disagree on whatever aspect, and so then, you know, any guarantee would basically just disappear into the thin air. So that also means if the lawyer tells you that I can't guarantee a success, it does not mean that it's a bad lawyer. It's, you know, it's an honest lawyer that does that, that communicates professionally with you. But the lawyer should be able to tell you whether you have like a hopeless case, kind of don't waste your time and money, don't bother, and maybe you should, you know, abandon your idea, or you should really try to make efforts to speak to the other side. Or they can say that you have a very strong case, so yeah, I would recommend going to the court on this and asking for this, like in terms of, you know, child support or for the sole custody. So, but the guarantees and assurances about 100% outcome cannot be expected. So then, like, there are two procedural mechanisms. So like there are two like procedural solutions that could also come into play where two parents cannot decide on a parenting plan, where one person where they see their parenting arrangements, their residences or their circumstances maybe differently, and they disagree on, you know, what the reality is around their child. So they could apply for an intervention. So interventions are facilitated, so they are ordered by the court, they are facilitated by experts in parenting, in child psychology, in like family counseling. So they would interview both parents, they would observe, they could also come and do like home visits, talk to other adults in the parent's life, talk to the children if the children are mature enough, and they write a report. And this report is presented to the judge. And so then the judge will look at that, and so then that would be a different source of evidence for the judge to decide on the best interests of that particular child or children based on what that independent, knowledgeable expert observed. So there are two types of interventions. So one is where the parenting expert is sort of more detached, so they don't necessarily provide they don't provide an opinion on what this family should do and what is in the best interests of the child, but they take the situation generally. They just provide information to assist the judges, and then the judges would make a decision about the best interest of the child. So these evaluations do not happen for free, so they have to be paid for. And usually, well, the parents agree that they would split the cost. Sometimes the subsidies could be available, and I'll show you the information about like an information resource here in Edmonton that you can contact to ask about any such subsidies. And then there is another type of assessment and intervention carried out by an expert who, again, looks at the situation of both parents. They talk to both parents, they talk to other people involved in his family's life, talk to the children, if the children are mature enough, and then they kind of take all of that and make recommendations to the judge that, you know, based on what they saw, what they heard, what they observed, like an arrangement, let's say like a residence, custody, decision-making, very limited access for the other parent, that is truly going to be in the child's best interest. These, again, are not free unless the subsidies apply, and usually if the parents want that third party, that objective independent assessor, like they should agree to pay, to split the cost of that. So the ultimate outcome of a court application would be like a litigation, a trial, contested hearings where both parents come and they bring witnesses and they talk in court and answer questions for a long time, and the lawyer for one parent gets to cross-examine the other parent. Sort of, you know, like those court experiences that we see on TV in legal dramas that kind of, you know, looks interesting, fascinating, attractive on the screen, but in real life it happens very rarely. Out of all family law matters, primarily because of the cost. You know, those multi-hour, multi-day hearings, trials, collection of evidence take an exorbitant amount of time and effort, well, from lawyers, and you know, for that time and effort, lawyers expect to be paid, and that's very expensive to even for an application for, you know, for a lawyer to speak for, let's say, half an hour in court, they might spend hours researching, figuring out the law, looking at all the evidence, talking to witnesses, kind of making notes. So a lawyer could well spend 5-6 hours for that half an hour court appearance as part of the trial. So that becomes a very expensive cost for one of the parties. So that's why, even like with the application, so usually, and the courts try to encourage like a resolution, like an order, agreement on the evidence, and agreement on what happened, without having to go through those extensive and time-consuming and costly processes. At some point, no matter how high conflict the family, the former spouses are, if they involve both lawyers, you know, both lawyers understand that like a trial and more aggressive court intervention would be very expensive. You know, it would be very time consuming. So the lawyers would try to get the parties to cooperate, to agree, at least on some points, to minimize that expense. Not all lawyers, you know, as a lawyer myself, like I will tell you that there are situations, unfortunately, where lawyers see that as a source of income, and they would encourage parties to participate in the court process and do various steps where lawyers' involvement is necessary, because that means lawyers' effort, that means cost, that means payment expected from the client to the lawyer. But by and large, lawyers recognize that there's just going to be cost, prolonged turmoil through the courts, impact on everybody's sort of, you know, psychology and mental health. So even if the court is involved in certain parts of the way, to give the final court order to decide, let's say, on the custody, on access, but figuring out the evidence, inviting experts, agreeing on portions of the parenting plan, accepting that one parent is suitable, the other parent can do ABC. If that can be done without the court, like without the trial, so then this is ideal, and this is what lawyers keep in mind, trying to get their clients to cooperate. So we have just a little bit of time left, and I have sort of like one last part of the presentation like one last topic. Can a parent move with the child? So the answer is yeah, maybe. That's kind of like a typical lawyer's answer, maybe, or it depends. Again, so we have to look at the circumstance of the family, of the life setup of both parents. Again, the overarching question is it in the best interest of the child to move with the parent? There's no presumptions, so that means that it's not always the case that the judge would decide that, you know, of course, the child should not be moving, because it's just better for them to stay in one place and avoid disruptions and kind of just to be accustomed to their routine and nothing unexpected, nothing new happening. So there is no such presumption. In deciding whether or not the child should be able to move, the judges are going to look at various factors and questions. So again, recognizing the best interest, recognizing that the child should have contact between two parents. So the judges would be putting their mind to questions such as, is the parent who is moving, are they willing and able to facilitate contact between the child and the other parent, maybe by periodic visits or by online virtual communication, given the technologies that are available at this time. Then the question could also be presented to the children. If the children are mature enough, they would be asked, well, do they want to move themselves? There is no cut off in age when the children are asked these questions. Usually it becomes the assessment of the judge. Sometimes an expert could be involved, like a child psychologist, like a family counselor, because they might have like their trained communicative approach to talk to the child. But generally, you know, the child is mature enough to understand what's happening. They have observed their parents enough and their lives with those parents. So it could easily be a 10-year-old who can sort of judge for themselves that moving to be with parent B as opposed to with parent A is a good idea or not a good idea. And conversely, a 15-year-old might not really be mature enough to kind of understand the differences, or maybe they don't care, or there might be sort of cognitive development limitations where it's not appropriate and it's just not going to help to make a decision for the best interest of the child, to ask for the child's opinion. But ultimately, the judge will have the discretion to decide. So they will look at, so like as I said before, if the child will have the ability to maintain contact with two parents, like what is the reason for the move? Let's say if the reason for the move is because one parent has always been involved with the child and they now are moving for a job, and the job is going to be really a much better paying job, which means that the parent could afford, you know, various kinds of extracurricular activities for the child and trips for this child. It is not feasible for them to be making trips back to parents, to the first parent, to stay, to spend some time visiting the child. So those considerations might well bring about the outcome that, yes, the child should be allowed to move. Practically speaking, that would be determined through the processes of the one or a couple of the processes which I described earlier, like in terms of interventions, yeah, like more control over your lives versus less control. So if the parents can, you know, sit down and figure it out between themselves, taking these, like asking themselves these questions, kind of reason for the move, how both parents are still going to be involved in the parents' life. So then they can do it by themselves, that's great. If not, then there are points of disagreement. Then again, depending on what aspects of disagreement, how strong those disagreements are, like a mediator would be just enough to kind of listen to both sides and try to bring the two voices together, or there would have to be a court application brought by one parent, let's say, who really wants the child to relocate with them, and they believe that it's really in the child's best interest that they leave their geographic, like the current geographic location. So they bring the application to the court, then the other parent can respond to the application, completely opposing and objecting to the move, or they can accept it on conditions that, for example, the child does move, but they come back in the summers to spend the greater part of the summer with this first parent, or the child only moves temporarily right now, let's say to a different, let's say, like even internationally. So the child moves for like the next couple of years to spend time in that other country with the grandparents, and and then come back to Canada in a couple of years, kind of like once maybe at the time when the grandparents are becoming too old, so then it doesn't maybe make so much sense for the child to be in that other country. Yeah, so all these kind of variations, nuances would be considered by the court to make a decision. If the child has already been moved, then and the other like without the parents' consent, so then action should be taken quickly. In a sense, you do need to speak to a family lawyer right away, because then there are different, like there could be different laws coming into play. There could be like a criminal law involved if there was something that actually amounts to child abduction. There could be immigration law involved, because then the parent status in the country, in this country or another country, is at play. So yeah, like I can't really say much about that right now, other than that becomes like very case specific and serious and urgent. So do engage a family lawyer if the child has been relocated without your knowledge, without your consent. So actually, I do have one more topic. So like whatever order was issued by the court at some point about custody and access is is not set in stone. Even if the order was pronounced as a final order, you can always make an application to vary the order because of the changed circumstances. Of course, you would have to justify why, let's say, the custody or the primary residence of the child needs to be changed, but the door is not closed completely. Interim temporary orders usually have an end date, so then you know something new is going to come for sure, and so then you basically go to the court again and get like another temporary order or maybe a final order. In final order, so there is no end date set. The order by itself may say that this order is final, but again, you can always come back to challenge the finality of the order, but you have to be able to show the new facts, the new evidence why a variation is necessary. The legal test still is the best interest of the child, and no order is ever permanent without any recourse, without kind of the door being closed indefinitely. So now we are at the point of 7 o'clock. So I'm just going to tell you about the resources that are available for further consultation, for further information gathering. So first of all, through my organization, Edmonton Community Legal Center, we have online video presentations. So if you would like to replay this content that I presented to you, if you want to learn about other aspects of family law, like child spousal support, property division, so you can access them from this link. I have it on the screen. If you can't easily capture the link right now, just go to eclc.ca and then you will see a tab resources then for family law, and you can find the presentations there. There are some other presentations available and print publications available on our website. Then there is a course, Parenting After Separation. So I mentioned it before, that kind of like helps you to start asking the right questions and to get as much detail as possible into the discussion between the two parents about the child's life when the parents separated. This is a free course. So as I said, it used to be offered in person. Now it's all electronic for the time being because of the pandemic. This is not a mandatory course, but usually the court would expect that the parents have taken this course and try to figure out sort of the details, at least to a certain extent, between themselves before they come to the court. So if an application is brought to the court, the outcome of the application may well be that the judge would issue an interim order that would expire, let's say, in a couple of months. And in the meantime, the parents or one of the parents is ordered to take this course, and the court would not consider giving any sort of more favorable decisions for this parent until they completed the course. And so the same course, so the same part of the government that put together the parenting after separation course, they also developed a parenting after separation guide, and I just have like the first cover page of this guide. I don't have the link for it quickly here and actually visible on the slide, but it's very easy to find on the internet. If you start a Google page and you type in Alberta parenting after separation parents guide, it will come up, and you will be able to access this publication. So there's just some description about the course, what kind of topics are covered in those 3 hours. Then there is another course, parenting after separation for high conflict families, where two parents really don't see eye to eye, and there's a lot of sort of, bad blood between the two. So then it's an enhanced type of course, parenting after separation for high conflict. It's available electronically. It's not mandatory, but again, a judge may order on a specific court application that both parties take the course before they come back before the judge to make an order regarding their child. And so then I also want to draw your attention to the Edmonton Resolution Support Center. This is the main kind of information hub for family law matters in Edmonton. I believe right now their ability to assist people in person is very limited because of the pandemic. It used to be very easy and free. You just go to the center as a walk-in, or you could make an appointment. But now, because, well, it's a fairly small location, so with social distancing restrictions in place, like I just don't know right now, like how many people they would allow to be at the center at the same time. But they do have phone lines running throughout the day from 8 to 4. And so whatever questions you might have about family law matters. So this is a good place to start. They're not staffed by lawyers, so you will not get like legal advice from a lawyer when you call this place, but they might be able to answer your question. Maybe your question is such that a lawyer is not necessary and you don't have to pay a couple of $100 for a consultation to a lawyer to deal with your matter. So they might be able to answer the question, or they might be able to direct you to the right part of the court website, or like another website that they could recommend. So the information provided is free. They are very busy right now on the phone because, again, of their limited ability to serve people in person, and generally public is more concerned these days to go into any places where they would be exposed to crowds. So that means that a lot of people are utilizing the phone, and you might be on hold for quite some time, but that's just the reality. You have to wait, or you can hang up and call them back later. Like, there's no easy solution to that. And I have the information, the contact information for this Resolution Support Center on the slide here. There is their phone number. Their address is there too. And lastly, I will say a few words about my organization, Edmonton Community Legal Center. So I'm stopping to share my screen. You have the contact information about us behind me as my virtual backdrop. We do provide family law assistance. We do have family lawyers. You can contact us and ask you a question of intake first. So everybody goes through an intake, sort of like similar how in hospital, you know, when you go to a hospital, you don't get to see the doctor right away. There's triage, and you know, you ask questions about your medical problem, about your symptoms, and then those triage people decide what kind of doctor you need. So it's sort of similar with our legal service. If you contact us, you will be asked questions about your matter, and then our intake would decide whether your matter is suitable for a consultation with a lawyer, or maybe first you should read the parenting after separation guide, or maybe your question really should be best dealt with at the resolution support services and not us. They will also ask you about your income, because one of our main eligibility criteria for our service is the financial, the income in the household. Our service is free. There's no sliding scale. There is no sort of limitation in terms of, you know, if you make, or condition that you make this much money, we can only help you with whatever portion. We cannot accept somebody who makes sort of like the average income but not enough for a private lawyer. It's either, you know, we accept you as a client and then we don't charge you, or we can't accept you because you just make too much money for us. These questions are also determined by intake. They will ask you about your family size, how many family members are living with you, how many family members are financially dependent on you, what your current income has been, and then based on your answers, they will tell you whether or not you qualify. And if you qualify, and if you have a legal question or legal problem that deserves being addressed by a lawyer, you will be given a consultation. This is our main service. So you will be given a consultation with a family lawyer. We have family lawyers on staff, and we also have volunteer lawyers who make themselves available for an hour. We used to offer these consultations as in-person appointments, but now because of the pandemic, sort of our default is to do this appointment by phone or by video if the lawyer and the client have the technology to be connected through video. And only if the appointment in person is necessary, then you would be asked to come in, and we have safety protocols in place. That usually happens when the client needs to sign something in the presence of a lawyer, like an affidavit or like a statement of finances or another legal document. But if such need does not arise, then you would expect the consultation to happen over the phone or by video. Yeah, so, and you have the phone number, the email address. Both ways are like fine to get in touch with us. We are experiencing a fairly high volume of calls right now, so please be prepared to leave a voicemail. I know that our intake cannot pick up the phone always, but I know that they will always listen through the voicemail periodically throughout the day. So if you call, leave a message and leave a number at which to call you, our intake will call you within within 2 business days. You can also send your inquiry, like you can initiate contact with us by email, which is also there behind me on the screen. We don't ask for proof of income, but if there are concerns, like if somehow you give us contradictory information, let's say you talk to one income person, you say one income, and then 2 days later, the same person calls and says another number, then we might have to actually see the documents. So like your tax assessment for the last year, your pay stubs to see how much you're actually making. But otherwise, we trust, we expect people to be honest and tell us how much they make. So on that note, I am going to finish. So we are past 7 o'clock. And actually, I see we have just 2 participants left. 12. And so then I'm just going to quickly look at the group chat.
Hi, sorry, I have just a few closing remarks for everybody. And we actually do have quite a few participants. I can't see the list. We have 1, 2, 3, 4, 5,
yeah,
6.
Sure. I just looked at the chat box. Yeah, I know that.
Oh yeah.
Yeah.
But yeah, so the closing remarks, we would just like to, that concludes our workshop session for today. On the behalf of the Somali Canadian Cultural Society of Edmonton, we'd like to thank Mrs. Kuranicheva for sharing her knowledge and insights with us. If you enjoyed this session, please feel free to join us with more upcoming workshops in the coming weeks. This information can be found on our website, www.somaliedmonton.com, and our Facebook page. Thank you all for joining us today. We hope that you gained new knowledge about the legal topics and hope to see you at our future workshops soon. So thank you, Miss Kuranicheva, and I hope you all have a wonderful night tonight.
Okay, well, thank you. It was my pleasure, and I guess I'll be back with you, I think, in a couple of weeks to talk about child support.
Perfect. Thank you. Good night, everybody.
Okay. Good night. Bye-bye.
Bye.